for the eligibility of the arbitrators to be nominated, other general criteria. We know more or less what's happening, but I just would like to, that's a fundamental issue. And who would like to take this? Yeah? Yeah.
Well, it's a quite interesting question. Greek state, at least, has tried to regulate it repeatedly. Also, both in the initial law 2331 of 1995 on the Legal Council of State, and more recently with laws dating 2013, and of course the new law on the Legal Council of State. To appoint somebody as an arbitrator on behalf, to act on behalf of the Greek state, the appointee must have specific requirements. An issue of great debate in the past has been whether such appointee may be an officer of the Legal Council of State itself. The matter was raised twice in Greek jurisprudence, once in 1998, when the law 2331, then in force on LCS, provided for the option to appoint such officer as an arbitrator on behalf of the state, and the Civil Tribunal of Athens then ruled almost immediately on 1998 in favor of a challenge of the officer of LSC who had been appointed as an arbitrator in a case, on the ground that he was practically a counsel to the state, so he could not wear both hats. And later on 2013, a provision passed providing that in all arbitrations involving the state, the appointee as arbitrator on behalf of the state should be an officer of LCS. This particular provision did not leave even the option of appointing somebody else. Almost immediately, the provision was stricken again, and the court, or the Civil Tribunal of Athens, ruled again that in favor of a challenge for such an appointee. And then the law was modified again and provides practically that the state can appoint either a law professor or a senior judge retired or in service, but still it has the option to appoint as well an officer of the LCS. We do not have data from jurisprudence indicating that LCS made an attempt in the past years, since 2014, to appoint one of its officers as an arbitrator in an arbitration involving the state. But theoretically, the option is still open. From my perspective, it's crystal clear and evident that an officer of the LCS, no matter how qualified he might be, and no matter what guarantees he may enjoy theoretically on the basis of the Constitution as regards his personal independence and the like, cannot act on, in a procedure where the state is involved. He is a counsel to the state before and anything else. He owes duty to the state by it's self-evident, so he does not meet the criteria to act as a neutral and impartial arbitrator, which is what we seek in arbitration procedure, in an arbitration procedure. So, coming back to who may be appointed by the state, once more, the law on LCS is very flexible and practically affords the option to the competent department, the competent arbitration department, to pick an arbitrator it deems fit and proper, and then the election is confirmed by the chairman of the LCS. An interesting amendment was incorporated recently with the new law on LCS, the law 4831 of 2021, which affords the option for LCS to comply with the requirements set in the rules of international arbitration, institutional arbitration fora, providing for different qualifications for the appointment of arbitrators than the ones set in our Greek law. This is a plausible amendment, since it's not always to be taken for granted that whomever meets the criteria of Greek legislation to be appointed as an arbitrator should meet the same criteria, for example, under the ICSID rules or any similar form.